to all the viewers. My name is Mohd Azam Khan. I am a third year law student at the Aligarh Muslim University, Centre Mullapuram, situated at Kerala. Currently interning at ubAdvocate under the guidance of Sri Jeevan Prakash, Advocate on Record, Supreme Court of India. So the topic which I will be going to discuss today is the doctrine of separation of powers, whether a rigid or a flexible doctrine. Actually, as we all know, this doctrine is of much importance in both the constitutional and the administrative law, as it deals in the powers of the different organs of the government. This doctrine is depend on the principle of Trias Politica, which means power must not be concentrated but separated. This doctrine, or we can say this principle, was firstly used by John Locke in 16th century and later on was developed by the Montesquieu in 18th century in his book Spirit of Laws. As per the Montesquieu Theory, there exist three organs of a government in which the power is divided. The first one is legislature, the second one is executive, and the third one is judiciary. Montesquieu further said there must be an end to everything, means to give power only to few ends may lead to the corruption, as absolute power leads to the corruption. So this doctrine of the separation of powers is must to make the workings of the government smooth. Later on, he provides three rules to make the applicability of this doctrine possible. The first one is one person must not be a member of more than one organ of the government. The second one is the one organ must not interfere into the functioning of the another organ, and the last one is one organ must not exercise the powers so assigned to the another organ. So now we will be discussing about the importance of this doctrine. The first importance of this doctrine is the nature. The nature of this doctrine is very rigid. Therefore, it is so accepted only by a few countries. The second one is it emphasizes for the supremacy of law, means the rule of law, rather than the wills or the whims of the officials. The last one is the independence of the judiciary. As we all know, everything has its defect, so is the situation with doctrine of the separation of powers. As far as the defects of this doctrine is concerned, actually this doctrine presumes that every organ of the government has its own power, but in fact it is not so. As Justice Frank further said, the enforcement of the rigid doctrines like the separation of the powers is somehow makes the workings of the modern governments impossible. The examples in this regard is, the first one is, as we all know, the power of the legislature is to legislate the laws, but still Indian Parliament is having power to punish those who breach its privilege by the virtue of Article 105 Clause 3 of the Indian Constitution. So was confirmed by the Madras High Court in its ruling A.M. Paul Raj versus the Speaker Tamil Nadu 1985, in which the Madras High Court held that the Indian Parliament and the state legislatures are having power to punish those who breach its privilege by the virtue of Article 105 Clause 3 of the Indian Constitution. The second example in this regard is, as we all know, the power of the judiciary is to deal with the civil and the criminal disputes and to provide the justice to the victims. But as we all know, the Indian Supreme Court and the High Courts are having power by the virtue of Article 225 of the Indian Constitution to frame their own rules for making their functioning smooth. As far as this doctrine and the Indian Constitution is concerned, in Indian Constitution, doctrine of the separation of powers is nowhere mentioned. But still, Article 50 under the DPSPs provides for the independence of the judiciary, but still, as it is clearly visible, there exists certain functional and personal interference into the workings of the judiciary. Same is the situation with the Supreme Court or the legislature, we can say, as some laws which is legislated by the Parliament or the state legislatures can be declared void by the Supreme Court. So now, some important case laws about this doctrine is the Indira Gandhi versus Raj Narayan, in which the Supreme Court held that the essence of the doctrine of the separation of powers is a feature of the basic structure of the Constitution. In my concluding words, I would say that the doctrine of the separation of powers is needed to make the workings of the modern government smooth, but its rigid application is not somehow possible. Thank you.